Hi, my name is Eric Olson, Director of HELPS. I just read an article today in Forbes magazine online that talked about the uptick of bankruptcies in seniors. And like many articles on the internet, part of it was accurate, part of it was inaccurate, and it left a lot of information out that could deceive people or lead them in the wrong direction. In this little video, I want to talk about why bankruptcy instances where bankruptcy could be a mistake or even a disaster for seniors. Okay, so let me talk first. Explain. There's two types of bankruptcies: Chapter 7 and Chapter 13. Chapter 7 bankruptcy is what you normally refer to as bankruptcy. We just you file papers, list your people you owe money to, your assets, and after you go to one hearing, and after a brief period of time, the debts are discharged or wiped out. Bankruptcy is fairly expensive, costs probably average between $1,500 and $2,000. There's a filing fee of $335. For a lot of seniors, they simply can't afford to file bankruptcy. And sometimes they may not be told that their income is protected and no one can touch it. So then the next question is, well, why do they need to file bankruptcy if no one can do anything to them? A lot of the lower income seniors, especially, or very elderly seniors, reestablishing credit is the last thing on their mind. And it's difficult to reestablish credit the older you get, no matter what anyone tells you. And for a lot of, since 2008, the Great Recession, creditors look at credit a little different way. It's not so much if your credit report, but it's also your income. If you have minimal income, they may not consider loaning you money because they can see you don't have the ability to pay it back. So when can bankruptcy be a mistake? Okay, each state has a set of exemptions that you're allowed to keep free from collectors in bankruptcy. Give an example, a home. Let's say you live in a state where the homestead exemption is $25,000, and you have a home that you owe $150,000, but it's worth, let's say, $225,000. So if you take $225,000 minus $150,000, that's $75,000 in equity. Obviously, if your homestead exemption is $25,000, even if you can double that for a couple of $50,000, you've got $25,000 in non-exempt equity in the property, or $50,000 if you're a single person in non-exempt equity, over and above the exemption amount. So if you file Chapter 7, a trustee could take that money or take that home, sell it, pay you your exemption amount, and use the rest of the money to pay your creditors. Now, obviously, you don't want that to happen. I've seen bankruptcy attorneys therefore recommend to someone that they file what's called a Chapter 13 bankruptcy. Under a Chapter 13, if you've got non-exempt equity in the property, in other words, equity in a home over and above the homestead exemption, and you want to keep the home, as long as you pay your creditors that money over a period of 3 to 5 years in a Chapter 13 plan, you get to keep the property or keep the home. Well, why is this a problem? Well, it's a problem because of this. Let's say you're on limited income. Let's say your income's $2,000 a month and you have a $700 house payment. So you're living off of what, $1,300. If you had non-exempt equity in a home of $25,000, then in a Chapter 13 plan, you'd have a payment of probably at least $500 per month for 5 years. So take your $1,300 and subtract $500 from that. That leaves you with $800. You're in utter poverty. And why would a person do that? Especially if they understand that creditors, unsecured creditors that you owe money to, like credit card companies or medical bills, if they sue you and get a judgment, it becomes a lien on the house, but they're not going to foreclose on your home. It just doesn't happen. They don't foreclose. So if you choose not to pay them, the worst that's going to happen is they're going to get a judgment. It'll be a lien on the house, but they can't take it from you. It'd eventually be paid either when you sell the house or after you pass, it'd be paid by your estate. But they're not going to foreclose on your home. So why put yourself in a Chapter 13 to live on utter poverty? Uh, you know, it's just not necessary. Yet I see sometimes bankruptcy attorneys advising people to do this. Um, so also, bankruptcy could be a mistake because if you really don't need to file, if your income is protected and all your assets are protected, there's simpler ways to get the collectors off your back. The article, and this is talked about an 82-year-old lady. It didn't say what her income is, but I could guess that it's pretty low because she got qualified to go to legal aid, and they filed a bankruptcy for her. Now, legal aid is good, but there's simpler ways to deal with this. Sometimes filing bankruptcy for a senior is like using a sledgehammer to kill a gnat. The Fair Debt Collection Practices Act provides that a person can send what's called a cease and desist letter to a collector, and they no longer communicate with them by phone or mail. They have to leave them alone. So filing a bankruptcy just to get relief from your creditors, sure, it works as long as you don't have problems in these other areas like I discussed. But for an elderly person who has unlimited income, a lot of them don't have access to less expensive forms of legal representation for bankruptcy. They couldn't afford it. And then it seems to be a waste of resources to file bankruptcy for someone for a discounted amount or free when that person really doesn't need to file bankruptcy. And there's really no possibility for them to rebuild their credit because their income is so low. So a lot of logic in this article just fell completely apart. But I see this all the time. Part of the problem is, I guess, there's not been a real good solution for seniors up to now, and that's why I started HELPS. And what HELPS does is we represent seniors and disabled persons who are on protected income such as Social Security, a pension, retirement, VA benefits, for the purpose of having an attorney, so collectors have to leave them alone. Under federal law, if a person's represented by an attorney, collectors can no longer call or send you demand letters anymore. They have to communicate with the attorney, and so that's what we do. We send a cease and desist letter to the collector, and we also represent the person as their attorney to receive this communication. It's pretty simple. We help our people ongoing, years into the future. We don't turn anyone away. So I guess if someone didn't know about HELPS and what we did, and they're being hounded by creditors, and it was difficult for them to deal with collectors on their own by sending a cease and desist letter, bankruptcy might seem like the only answer they have, when in fact it isn't. And that's one reason I do these videos. The magic thing about HELPS is that we actually represent our people to get communication. It's not just provide them a letter and you send it out, or we send it out and we're gone. We're always there for them. If they ever have a question, worried, or scared, they can always call us. We send out 4 newsletters a year. We do many other things other than represent seniors to stop collector communication. We help people get on non-collectible status with the IRS, help get on income contingent repayment plan on student loans or get them discharged, and we'll tell people about other options they might have. We'll tell them about Section 8 housing, talk about food programs that are available, transportation alternatives. Sometimes a reverse mortgage makes sense. So if you've got any questions or you're in this situation, you can always contact HELPS at our phone number 855-435-7787, or visit our website, www.helpsishere.org. Help with an S on the end. Have a great day.